For most Filipinos, death is a tough subject to discuss. Most do not plan ahead and therefore leave their loved ones to fight for what remains of their properties or estate, as is the legal term. Most Filipinos are not aware of the different ways they can impart their estate to their family and relatives. Aside from testate and intestate succession, another option they can consider is estate planning. Estate planning is a process of arranging for the distribution of the testator's estate according to his personal wishes and requirements. Similar to testate succession, only with estate planning, it eliminates uncertainties such as debts and reduces taxes and other expenses that come with death and distribution of assets. Estate planning involves tools such as wills, trusts, beneficiary designations, powers of appointment and attorney, gifts, as well as life insurance. Similar to testate succession, estate planning must undergo a probate proceeding in order for the heirs to get what is rightfully theirs. A probate proceeding is a process in which the estate of the deceased will be divided according to his or her wishes. A series of hearings must be held to establish the death of the testator, the genuineness of the will, and the competency of the testator at the time the will was made. This is done for the protection of the expressed wishes of the testator and not for the interest of the beneficiaries. Therefore, the questions are, what is estate planning? And can this be a better alternative for testate succession? Since estate planning involves taxes, what are these? How much are they? And who should pay them? And what happens in a probate proceeding?
Good evening. You are watching Legal Help Desk on 9TV. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Karen Jimeno.
And I'm Attorney Nepomuceno. In our previous episodes, we've discussed your legal rights on testate and intestate succession. Tonight, as part 3 of our discussion on succession, we'll discuss your legal rights on the following topics: estate planning and probate proceedings, what you need to know about estate planning and how this can be an alternative to testate succession or the making of a will. We'll also discuss what you need to know about probate proceedings and how.
Our guests for tonight are Attorney Alfred Lazaro, Managing Partner of the Lazaro Law Office, and Attorney DJ Jimenez, Law Practitioner and a Professor at the University of Santo Tomas. Good evening, gentlemen.
Good evening, Attorney DJ, Attorney Dong.
Hi, good evening.
Welcome again for both of you. Suki na kayo kasi we're touching on this topic again. No? It's kind of related to what we discussed before in previous episodes where we touched on testate and intestate succession. Now naman, we're going to be talking about estate planning and probate proceedings.
Yeah. And Rod, you said a mouthful kanina, mga probate proceedings, testate, intestate succession, but I think for the benefit of our viewers, not to be too legalese, in short, this is all about mana, yung inheritance. If someone in the family passes away or a relative, this is all about how you can basically get your inheritance or how you give your inheritance.
A lot of people don't want to talk about it because it's normally about death or, you know, they think about death, di ba? Yun ang unang pumapasok. But I think perhaps we'll start off with that. No? Maybe at Attorney Dong, you'd like to enlighten our viewers why it's important to talk about estate planning and why it shouldn't be such a morbid topic.
Rod, just as a starting point, Attorney Dong was saying kasi kanina, yung topic nyo pang mayaman na. But I want to erase that misconception. This is not just for the wealthy because to the extent that you have something, the least that you want is to either depreciate what you're leaving to your mga descendants or yung mga may iwan mo. Make it smaller by paying a lot of estate taxes. Kasi kung meron namang way na legal to reduce that, why not, right? So maybe Attorney Dong and Attorney DJ, that's something that you can enlighten our viewers on.
Well, estate planning is first and foremost, it's a desire of the living to be able to transmit whatever he has to his heirs at the cheapest possible amount, you know? Less hassle. Now, what did I say is basically normally a problem of the rich people is because if the estate is small, you don't even have to pay much taxes already because the bracket will be low.
In fact, what is the bracket? At what rate or the value of the
Well, I
asset
think
that
if
you
it's
don't
up
have to pay
to
any
1
estate
or
tax?
2 million, there's even zero tax.
So
2.2 million probably.
So 2.2 million ng estate mo, bali you don't have to pay any estate tax.
Not necessarily if the property left is a family home. So to the extent of the first 1 million, exempted yan. And then meron ka pang straight na 1 million plus the first 200 is zero rated. So in effect, if the value is 2.2 million, even if you proceed with the usual testate proceedings, whether extrajudicial or judicial, hindi ka rin magbabayad ng tax. But again, estate planning is very important because this will give you a better way as to how you would like your property disposed of in anticipation of death or incapacity.
So what are the different options? I mentioned earlier in the introduction nga, there are trusts, there are donations inter vivos while alive, no? You have life insurance. So perhaps we'll focus on that before we touch on probate proceedings. So let's begin. For example, I want to plan my estate. No? What's the very first thing that I need to do?
Well, you have to make an inventory of all your properties. And then by coming up with an inventory, then you can devise what would be the best option for you. Indeed, the lesser payment of taxes is a consideration, but more than that, yung desire mo nga remember, unlike other jurisdictions, in the Philippines, although you can make your own will, but you are limited by the substantive limitations provided for by law. If you have compulsory heirs, you cannot just bequeath your property to
the church,
any person you wish. or to the
Attorney
church.
DJ, I'll stop you there. Let's translate it for the viewers na hindi lawyers. When you say limitations, because meron kang compulsory heirs, ito yung mga, for instance, if you have children, you're really required to give property to them. So
Yes.
kahit sa will mo, nakasulat dito that you're leaving your properties to your best friend and to your parents, kahit papano, yung will na yon, before it is satisfied, you have to give the
them
properties first
the
to
legitimate.
your
The
children.
You have to
Legitimate.
give the legitimate, the compulsory heirs.
Unlike Lex Luthor, di ba? Yumaman siya dahil pinapirma niya yung...
Yung ano
Are we
that
talking
movie.
about the character from Superman?
Yeah, because
This is what I get for being surrounded by men.
Just to
Did
make
you watch
it simple.
Superman Returns? No, but yeah, I think let's clarify that kasi a lot of people are asking me, Radi, I have a will, or my lolo had a will, but left it all to kunyari, girlfriend niya kasi maybe the lolo already died. Is that possible? No? And so to clarify, in the States or in other jurisdictions,
Yes, you can.
It's possible, right?
Yes.
But not in the
But
Philippines.
not in the Philippines.
Well, if he is a Filipino citizen, no.
Yeah, so basically you have to set aside nga.
And if he has compulsory heirs, of course.
Yes.
And that is why estate planning will come into play. Because in estate planning, while you're still alive, you have an absolute right as to how you want your properties disposed of.
Parang in a way, you're having an extrajudicial partition while you're alive.
Parang ganun.
Something
Ang
like that.
estate planning kasi, sir, to general extent, anything goes even before your death or even yung probate is part of estate planning
But
also.
Attorney
So,
DJ, sorry, go ahead. Finish.
so yung estate planning very wide. So even buhay ka pa, pwede mo na ring
I-traffic.
i-assign, i-traffic.
But
Oo.
Attorney DJ, in that case, you might be subject to either donor's tax or pwede bang maging possible din na subject ka to sales tax. I mean, if I'm already giving, so I know that in terms of, kunwari, I want to leave properties to Rod, pero I know that kung sa will, because he's not a relative, I have to give properties to my husband. I'm supposed to, para isa siya sa mga compulsory heirs ko yung husband ko. If I want to give properties to Rod, now that I'm still alive, then anong types of taxes yung maaaring kailangan kong bayaran because of that transfer of property?
Well, again, it depends on the mode of estate planning that you will enter into. If it is a sale, although simulated man, you will have to be subjected to the capital gains tax. Kung
So even
donation
if he
naman
pays
siya,
piso to me,
Donor's tax.
even if
Donor's
I pay
tax.
1 peso lang siya sa
yes.
akin.
In some cases, what they do is they convert the property into a property of a corporation. So wala siyang gain, exchange of property to property lang, nagiging shares of stocks.
This is the 40C2 exchange, the BIR code 40C2.
Yeah, something to that effect. Although now I heard that BIR is very strict. So ang assumption dyan...
Okay, I have to cut you off. When you say very strict, you're saying that they're not issuing a BIR ruling or they're not allowing this tax-free exchange? Kasi the way I understand it is that I have property, I will set up a corporation, I will transfer my property into this corporation, and in return, I will get shares of stock. Is that correct?
Yes.
All right.
And
that's
before,
tax-free.
under the tax code,
Not
that
really
is not
tax-free
something-
kasi wala ka ng gain eh. Kumbaga, binigay mo lang yung property mo.
Correct. So, but
So it's a
in other words,
swap.
it's a swap. So there was an exchange. In other words, my property has been converted to a shares of stock, and which I can now give to my children or sell to my children at a lower rate. Is that how it
Yes.
works out?
Yes, you can assign it to them later on.
You can assign it. So people do that. So basically, people are doing that so that they'll pay na lang the lower capital gains tax, which I think the maximum is 10%, vis-a-vis the estate tax, which is 20%. Is that correct?
Supposedly, but again, since you're putting up a corporation, you have to also be responsible as a corporate entity. So technically, you really have to submit the GIS, the
There are a lot of
annual-
concomitant obligations also when you have a corporation.
Because basically, you have a corporation.
too much
now.
paperwork.
Yes, it's a corporation.
Too much
Kasi
paperwork.
I would understand if your property is a property that's earning. It's an earning asset, so you file income tax return, etc. But let's say it's just it's a family home. Should you, as part of estate planning, should you set up a corporation, putting the family home there when you know in fact that it's not really earning asset?
And that is where nga estate planning will come into play if it's impracticable, given that anyhow you will not be paying more taxes, then might as well go through the process.
Yeah, and is that even allowed to constitute a family home? It has to be in the ownership of either of the
decedent,
spouses,
yes.
not a corporation, right?
Oh, yes,
to qualify
yes,
as a
yes.
family
No, because
home.
it's for corporation already, it ceases to be the nomenclature changes, right?
So
It
they
now
bec-
becomes a corporate
So
asset.
the husband and wife become fellow
No,
shareholders.
That's right. It becomes
Alright.
now a company asset.
Okay.
Okay.
Sige,
Alright.
nice start for our first
Yeah.
job, but at least for now, we found out that that's one of the modes that you can put your assets in a corporation in order to basically make the allocation efficient. But I guess we'll go into other modes of estate planning. But for now, we'll have to take a short break. Legal Help Desk will return, so stay tuned. You're still tuned in to Legal Help Desk on 9TV with our guests, Attorney Alfred Lazaro and Attorney DJ Jimenez.
Okay, so Attorney Dong, Attorney DJ, the usual thinking, at least before, a couple of years ago, was that you try to avoid estate tax as much as possible because of the high rate. So people what they would do is donate inter vivos. They would donate
Habang buhay pa sila. Oo.
to their children, in thinking that
They would pay
the rates
less.
the rates are lower, the tax rates are lower, and that they'll just keep the use of frac or the right to use and the right to benefit from that property, but the naked title is already transferred to their children. Is that still a viable estate plan strategy?
Well, it depends again on the purpose of the person who wants to bequeath the properties. Because there are also disadvantages to giving the property immediately to the.
Okay, what are those disadvantages?
What if it turns out to be a bad
Can't
kid?
you
Very
put that in
difficult
your
again.
deed of donation?
So
That,
you're putting
for
a lot of
instance-
restrictions already.
Yes.
See?
But
so what's the
but it
point
can
of going
happen.
through? Yeah, that's why other people. That's what he said. There'll be other ways within. You want to retain control over the asset, but at the same time you can pass it on at the cheapest possible rate to whoever will be your.
But you can keep use of
Heirs.
fructuary rights, right? Like for example,
Yes,
I'm
exactly.
donating this title, but I keep use of fructuary rights. The rental income from that, I would.
Yes, but what if he wants to sell already?
there
Or he
might be
wants
more
to mortgage
problems.
the property.
And then another thing would be, Attorney DJ, you
The
mentioned
donor's
earlier,
tax
yung
might even be more expensive in the end.
Okay, how much is the donor's tax?
There's a table,
There's a table
of,
also.
rate. So depending on the value. So again, you go back to the basic. If it's not as much, then maybe there's no need. In fact, the best thing to do is to first seek an assessment. You look at the valuation of the property, and if in the end the estate tax that you will be paying would not be as much, then do not donate anymore.
For properties like land, houses, usually they appreciate in value. At the time of the death of the person whose property will be passed on to dun sa mga naiwan, what is the basis for computing the tax rate? Is it the book value or historical value of that property, or yung current market value at the time na mamatay or
There
the
is
person
evaluation
passes
of the
away?
internal revenue on every piece of land. They have their own assessment already.
And they can choose market value.
Well, they can choose that, whichever is higher.
Usually, whichever is higher.
Whichever is
Okay.
higher.
And then let's go back to a mode of transferring. What if it's what you mentioned earlier, Attorney DJ, na simulated sale? Meaning, I want to give property to Rod while I'm still alive. So, we come up with a contract of sale because based on our computation, mas mababa yun sa donor's tax ko, ibenta ko na lang sa kanya. But he only gave me 50 pesos in return, for instance, for a property that's really worth 1 million.
Then,
Ano
yeah.
yung tax implications?
No, the BAR can, of course, disregard that.
Yes.
You can disregard it.
It's a simulated sale.
Simulated. They'll
So,
go for
ang
market
magbabayad
value.
And
ka pa
still,
rin ng
even if
donor's
you pay
tax.
50 pesos, I mean, they can still apply the proper tax because
Whichever is higher
yeah.
is the rule.
Okay. So let's shift from donation. There are other modes like trust. No? We always hear that. Like there's normally a grantor with a trustee who he entrusts this property or this asset to a particular trustee who then keeps that or uses that property for the benefit of a beneficiary. Can you give your 2 cents worth on this mode and whether there are tax savings in trusts?
Trust, I'm not much familiar with trust, but I think there may be some complications. But since when there is a trust agreement, hindi mo naman tinatransfer yung entire so
You're basically saying that if in the event that let's say something happens to me, I die, you will take care of this property for the benefit of my son, let's say.
no, trust is basically, it's very complicated, right? What do you assign to the trustee?
And
There are a lot of variations. in that.
can you give a little bit of an idea of the tax implications there? Let's say if it's an irrevocable trust or it's an irrevocable trust, are there any tax implications? Sa mga
kasi if it's a trust, di ba, parang it's not really yours.
yeah.
You're holding it. Baka estate pa rin ang papasok.
So wala, hindi pa in other words, hindi pa na transfer.
Hindi
For
naman
purposes of
sa'yo yun
computing my estate, hindi pa na consider na transfer
Especially
yung
if the ownership
yung property
isn't transferred.
hasn't been transferred.
Yes,
It's just
sir.
pure benefit. All right. Okay. All right. So how
So what
about
else? What other estate planning device? Parang ang dami nilang nasa-shoot down.
Oo nga.
Okay.
No, as I said,
Yeah, I know.
it depends
I'm
on
just
what
saying it
you
depends
want.
on what you need, right?
Yeah.
So meron tayo, you can form a corporation and transfer properties there. You can also give
Donate.
donations at the time you're still alive. And then, of course, if it's a sale, it has to
But
be a
of
real
course, may
sale.
mga
or
moral
else-
dilemma ka dyan kasi theoretically that shouldn't be allowed because that's a simulated transaction.
And it's
Especially if the intention is that the donation will take effect only upon the death of the person giving it. That's considered
Mortis
under the
causa.
law as a mortis causa,
Causa.
meaning ang ilalagay pa rin nila is an estate tax,
Yung
right?
insurance proceeds is also one way of doing it. If you designate a beneficiary as long as there is an insurable interest,
So
that
is that
in a
subject
way-
that's subject to estate tax in there?
I think if
Hindi
it's
na,
Hindi na.
hindi na
Exception.
because they're
Okay.
the beneficiary,
All
right? Okay.
So it's not part of the estate. All right. We have a couple of questions from our viewers. Actually, marami. So Tim is asking, I plan on applying for life insurance. So we're discussing that. Can this be considered as part of estate planning? What should I include in my life insurance?
Very good
Ayan.
question.
Good
I'm
question,
also interested
yeah.
to
Timing.
know about this.
part of estate planning. Well, I don't view it that way because you
Yeah.
just try to ensure that something is being given to his heirs when something happens to him.
Yeah.
It's not by per se already estate planning, although it's
It's not part of the estate.
Yeah, it's a device.
So it's more of actually planning for the future of your
it's
your
more
children.
insurance itself is to be able to give some or leave something to your children.
Yeah. And again, to clarify, any proceeds from life insurance is not subject to estate tax, correct?
Provided, I think it's not.
Irrevocable.
Yes.
Depends if
Depends.
it's
There's also some
irrevocable,
qualifications on that.
So kailangan irrevocable. Okay.
And also, provided that may mga exceptions. Like I think you don't make the estate as the beneficiary.
Oh, yeah,
Otherwise,
okay. Because if the estate is the beneficiary, then
it's taxable
it's
also.
taxable. Okay, all right, that's a good
Okay.
point. All right.
We have another question from Rodelia. May I know the process in filing a deed of donation? What are the things we need to remember before and after we file one? Does it require that the deed need to be signed by the donor in front of the lawyer, since she finds it difficult to go to places due to old age? So mukhang older na yung magagawa ng deed of donation.
Actually, under the law, there is no specific form of any agreement, except that if the law provides a particular formality, either for enforceability, to make it binding to third persons, or for validity. In case of a donation, this is one type of contract where the law requires a formality, which is, it must be under oath, both the act of donating and the acceptance, for purposes of validity.
Okay. So, under oath meaning kailangan nila ng notary
so,
public.
pag yung acceptance, hindi under oath, yung donation lang ang under oath, the donation is not valid. Kasi here, the formality is determined for purposes of validity.
I see. So, requirement yun.
Requirement siya for validity,
validity,
to be in a public instrument, both the acceptance and the donation.
Okay, all right.
That answers the question whether you need to be in front of a lawyer.
Yes.
Especially on notarization, I think the answer is yes.
So Rodelia, you need a lawyer. You need actually a notary public.
All right.
Okay.
Okay, so now...
And if I may add,
Yes.
if the mother cannot leave the house, you can request a notary public naman, provided it's within his jurisdiction, to go to the place and have it subscribed before.
What about witnesses? Do they need witnesses?
I think so, just to be safe. No? There has to be
Normally,
some-
documents require witnesses.
All right.
Okay.
Now, okay, so we have another question from Ines this time. Ines wrote, my grandparents died in the U.S. in the 80s and left a small residential lot, but this lot was not partitioned by my father and relatives. I'm now afraid that we'll be paying a big amount of estate tax plus penalties since it was not partitioned for more than 25 years. What are the rates for estate tax? Does it depend on the size of the lot and how much it is valued per square meter? So, so the grandfather died 25 years ago, but never partitioned it to her dad, to her parents. So now, what happens to that?
They can resort to what we refer to as an extrajudicial settlement of estate, even if it's 25 years ago. Ang value naman will be computed as of 25 years ago.
As of the time of the death.
There may be penalties, but if the value is small, then it's not gonna hurt much. But I do suggest that they proceed now with the extrajudicial settlement of estate na lang. If all of them can agree
on
then that is better.
So that means they agree among themselves without having to go to court. It's in an agreement.
Yeah, the lawyer will prepare an extrajudicial settlement. This will be published, and it becomes now they have to pay the estate taxes, and then the property can be transferred to whoever. In fact, they can even resort to an extrajudicial settlement with sale. So if they want to assign a single person to own the property for purposes of selling it, or there is a buyer, it will be devised in a single instrument, which is the extrajudicial settlement with sale. So isang transferring
na
lang.
to a third
yes,
party.
direkta from the decedent to the
buyer.
So yung title, hindi na palipat-lipat
Hindi na.
From the parents to
Yes.
the children.
Paano yung taxes pala nun?
Dalawa. Siyempre may capital gains, may estate tax.
And then I guess to answer Ines's question, sabi niya kasi, what if the magkano raw per square meter? Actually, it's based on the total value of the
property.
lot. So it's not measured per square meter.
And there is evaluation already of the internal revenue. Magkano yung lot.
Okay. Thank you, and we still have a lot to discuss, but now we'll have to take another short break. Legal Help Desk will return after these messages. You're still watching Legal Help Desk on 9TV with our guests, Attorney Alfred Lazaro and Attorney DJ Jimenez.
Okay, so Attorney Dong, Attorney DJ, let's talk about probate proceedings naman. No? People hear about that, a little bit allergic with it because they don't know what it is really. In a nutshell, what is probate?
Probate is a proceeding wherein you bring a will to court for the court to determine the validity of the formalities of the will, for it to be passed on to the heirs for the implementation of the contents.
Okay, so it's during this proceeding where the court will say, oh, hindi valid itong will na to because it failed in certain formal
You first go with the phase one, which is due execution, the authenticity of the will, right?
Right.
And then once it passes that stage, then you go to the intrinsic validity of the will.
The substance.
The substance.
That's
Okay.
phase two.
All right.
And then if I were someone who, of course, either left a will and also did estate planning, meaning gumawa ako ng trust, I also executed a trust, how do I know or how do I make sure, do you have tips na it will really be executed when I pass away? Because usually a lot of unpredictable events happen
Well,
afterwards.
the execution will have to come from the executor.
So is there a way for me to assign someone
in the
to
will.
make sure?
It's in the will.
It's in the will.
If it's not in the will,
Then the court will intervene to supplement.
to determine
whatever,
an administrator.
Yes. No, the executor.
The executor, okay.
Yes. After that, and then the provisions of the will have to be implemented by the executor, and the executor will have to be accountable to the court that everything is being followed because he posts a bond, takes an oath as an executor.
Okay, I think
And
Attorney DJ has-
yung question niyo po, if there's a guarantee, in reality, there are instances when the heirs would no longer probate the will for practical considerations. They will just consider the disposition and have it settled extrajudicially. So there's really no assurance because you're dead. But the only way to assure it is that when you file the probate of the will while you're still alive. Then in
So
that sense,
you can do that.
yes.
While you're
Papa-approve.
Our
na.
laws do not prohibit that but I do not know if in the Philippines very common yung
probate mo na.
ipoprobate mo buhay ka pa. But that is a lot easier
That's
kasi
easier.
nobody will how can you
And you
question
can testify that this
Yes,
is
you
really
will.
my will.
Yes.
And you don't have to undergo the, like, at least for those na taga-mana.
wala nang
they have-
mag-o-oppose kasi
Exactly.
normally syempre pag pinrobate mo yan mahabang proseso.
But there might be
long
problems
process.
there. For example, if let's say if I probated I had my will probated
While
now
you're
while I'm alive, but late after that, let's say it was approved, no, I either add more assets or I have less assets by the time I die.
No, but
Di ba?
usually
Ano yung-
kasi in a will, the assets, the division would be naka-percent, meaning half of my
No, but
estate,
let's say nga yung sa will, it's very specific. I'm giving this asset to
So it stays there.
Yeah, it stays there, di ba? Kasi
Right.
ang devices and gifts, it's very property
But
specific.
because it only takes effect upon death, right?
Right,
So,
right.
Under the,
Kaya nga.
under the civil code.
In other
So
words, kung-
technically even if you probated your will, you can still
You
do
can still
anything you
dispose.
want.
anything you want,
In
right?
fact, even if I'm going to give you the house, if I
Yeah.
want to sell it while I'm still alive, I can still sell it.
You can even prepare multiple wills if you wish. No?
Because I guess my question is, if you have had your will probated at a time when you had X amount of assets, by the time you die, your assets were not the same, and therefore legitimes were affected. It can be
Also,
Yes,
it can
so,
be invalidated, right?
but the probate nga kasi, as attorney said earlier, would be limited initially to the
Just the form.
due execution.
due
execution,
execution. The disposition of the
Okay.
will, the substance will come later.
Okay.
And as what Karen said, normally nobody says, I'm going to give my house to this. Normally, percentage yan.
All right. Okay. All right. So where can the testator file for it? Kunyari, if you
Or the heirs, maybe.
The heirs,
For the heirs.
the heirs will file it immediately upon discovery of the will.
Which court?
The
Should they go
residence
to?
of the
Depends on the
last-
amount, no? But of course, it's a will. Normally, it's beyond the jurisdictional requirement of an MTC. So it goes to the regional trial court.
So pwedeng kung less than 400,000 sa MTC, and when you talk of the venue naman, usually the
Residence.
last residence of the
The
decedent.
state.
All right.
If out of the country, then wherever his property is located.
Okay. All right. We still have some questions. Twitter and Facebook. Our Twitter and Facebook pages are burning. So Sharon is asking, what will happen to the property left in case one of the common law partner dies?
Wow.
Very good question.
Well, again, how long have they been together? Because common law means they maybe live in, right?
Yes. Yes.
If they were only living in for 6 months, what are we talking about? Nothing.
Okay.
Yeah.
Right?
Assuming
And
they're already
and the
qualified.
common law, whoever he or she is not an heir.
Here's my
Common law.
question, Attorney Dong. Right now, diba, after 4 years, you're considered common law. You have a common law partner, and then
It's 5 years.
5 years, and then you can have that certified, right? Yung common law partnership, and then there's a recent provision in the law that allows yung sharing of the properties.
You're deemed
between
co-owners if you've been
co-owners.
living in together, husband and wife, for 5 years.
Yes. So, in case your common law partner or yung ka-live-in mo for at least 5 years passes away, can you then claim co-ownership of properties even without a certificate of that common law
Yeah, as long as you
relationship?
can prove that you were living in for 5 years and that you were living as husband and wife. You know? 5 years would suffice. And then if something happens to one of the parties, right, you first break the property.
The co-ownership.
Co-ownership first, and then the remainder will be the estate now of the one who died. Right? That's the one which will be partitioned among whoever are entitled to it.
Yes. And something we have to clarify to our viewers, common law partners does not equate to being married. So kung yung ka-live-in nyo ay legally married pa to someone else pero separated lang, it's the legitimate wife who has, or husband, who has the right to the properties or the inheritance.
So in this case, you have to resort to estate planning in anticipation to what
What will happen.
to you.
So dapat iiwan ko.
That's the time when I would say estate planning is very important.
Lalo na kung
Because
may
sometimes,
kapitbahay.
yes, sometimes it's not really fair. Biro mo, nakasama mo for 20, 30 years, and then if something happens to your partner, then the wife
Yeah.
suddenly, or the husband suddenly appears, oh, I love you
Okay.
so much. Because
It's not-
so
it's
Yeah.
not uncommon.
And
It
another
happens.
question
Yeah.
pala,
It
what
happens.
if same-sex? Kasi sa atin walang same-sex marriage. So what if you have a relationship with yung dalawang males? They have a common law, they've been living together for 10 years, so over 5 years, but they're same-sex. Obviously, they cannot get married. Can they still benefit from this common
Common
law
law,
relationship?
Well, again, it's a $64 question because do we already recognize same-sex?
So it's not certain.
Because
We don't
Unless you
recognize
can probably prove that you
don't think-
invested on the property
As co-owners,
as
yes.
co-owners,
But not as
a partner.
live-in partners.
So they cannot automatically benefit from that provision.
Okay.
Okay. We have another question from Boji. I recently came into possession of my grandfather's original last will, which was never submitted for probate since his death in 1965. I'm an heir and would like to dispute it. Can I be the petitioner and dispute it as well?
So why
Why-
dispute
why
when
is
there
this-
is no need to present the will? If you think nobody was presenting it, what's the point? of
Since
spending?
1965.
Yeah, so it's not there. There's no will. So there's nothing to
effectively, I mean,
dispute.
he doesn't have. He's not
There's
obligated.
nothing to oppose because there is no will yet being implemented. Right?
So in other words, he's not obligated to have
Yeah,
it
so
probated.
if somebody now would want to introduce the will, that's the time.
You
can
dispute. Is he going to be civilly or criminally liable if he held on to the will and withheld it? Meaning,
There is
alam niyang
a-
nandun pero ayaw niya i-present for
No,
probate.
there is a requirement that it should be presented. In fact, there's a provision in the rules that the court can direct the holder to present it to the court.
Okay.
But
so,
if no one, you're saying if no one knows it, then he doesn't have to.
Yeah, right.
Yeah.
Exactly.
pero is he committing an offense by withholding or by hiding the will?
Yes, because they're mandated to surrender.
Oh, okay. So, Boji, you have to present the will.
What you only have to do is ask the person who has it,
Siya ata eh.
No, he said he
found it.
learned about it, that he wants to dispute
He
it.
found it. He said he found it.
He found it. Oo.
Yeah.
Siya yung nakahanap eh. So he
He
has
recently
to...
came into possession of
Yeah,
my
so
father.
I guess he has to present it, and then kung meron na lang doon feeling niya na inaccurate, then he'll dispute the will.
Yeah.
But he cannot hide it.
Yeah. Okay, he shouldn't hide it. I mean, I guess he's obliged.
Baka
to, so.
mami sa tayo si Sian,
Okay.
sabi sa legal age, di pwede ko itago. Okay.
Okay, he's obliged. All right. Our next question is from Gina, and I'm one of the beneficiaries of my grandfather's will, which was made in Canada sometime in the year 1986. He left a property in Compostela. Can we use his will to transfer the property to us, the beneficiaries left here in the Philippines? His sons and daughters in Canada were not mentioned in the will as beneficiaries. How long will it take to probate, and how much does it cost for probate proceedings? Nako, mahirap yung mga how much na yan.
Mahaba lang. No?
Ha?
Did,
So, yeah, in this
she
case-
mention the nationality of...
Yun nga, it didn't.
No, but
That's
no,
what
but
I'm
no. But
curious
we have
about.
to assume it's Canadian because there were the beneficiaries were not
Included.
The children were not
Children were not
included.
Or maybe we can qualify. Assuming the grandfather
Is national
was
of
already
Canada.
Canadian, and then he
Yes,
did
so
not
it's
include
valid.
his sons.
The disposition is valid.
The national law in Canada will apply.
So that they would have to check with Canada if it's valid for the grandfather not to include his
Compulsory
children
heirs, yes.
or his compulsory heirs in the will.
Kasi our viewers should understand that once you're a Filipino, anywhere you go, you remain
To be
Filipino. So our laws on succession, Philippine laws on succession will follow,
Still apply.
even if you're in Canada.
But if you're Canadian already,
If you're Canadian, then the national law in Canada will apply.
So in short, kung Filipino pa yung grandfather, even if he made the will in Canada, he cannot eliminate his children from the
because
will.
they are compulsory heirs unless he excluded them on valid grounds of disinheritance.
what if dual citizen? Dual citizenship?
Oh, well,
Eh,
from the
will
point
be
of view of the
Filipino.
Philippines, Filipino.
Filipino
Yeah.
siya.
sige.
Okay.
All right. Okay.
So we have another question from Wilfredo. My father died 10 years ago, and until now, his will has not been probated. One of my brothers died 2 years ago and is survived by his illegitimate daughter. Will she be entitled to my brother's inheritance, even if our father's will has yet to be probated? Can we dispute this during the probate proceedings? So magkasunod na deaths.
I think by substitution, nag-acquire na yung rights niya nung namatay yung
Yeah.
So
Who died first?
The father died first. So I
first,
think
eh.
they have to determine what the share of his brother was, depending on...
assuming it's equal,
father's
then nung namatay yung father by substitution, she becomes entitled to it also.
So they cannot dispute
They
dun
cannot
sa-
just remove her.
But I think she's illegitimate, right?
She's illegitimate.
So there is no right of representation.
Okay.
No,
right.
good
No,
point,
good point.
Attorney Dong. Okay, so
no.
technically, pag in this case, if the
But then
child
it goes,
is illegitimate,
what, a Christian, it goes to the brother, right?
so yeah, we
Anong
have to
tawag doon?
qualify
There's
pala.
a term for that.
That's yeah, I mean, there's
Iron curtain.
no, there is what you call, illegitimate cannot, has no right of representation from the legitimate one.
So that's what
There's
we
a
have to
barrier.
qualify here. Oo. Normally, if
curtain
in this
rule ba
case, namatay yung father and then there were children under him, and then one of the children dies as well, yung grandchild can substitute the father in terms of inheriting from the grandfather. Pero kung illegitimate, hindi pwedeng mag-substitute. So, yung mana nung namatay na anak will pass on to the siblings who survive.
So the fact that illegitimate children are compulsory heirs, at least they're given half the right of one legitimate child. In this scenario, being an illegitimate child is really a disadvantage.
Well, because there is no right of representation.
Dun sa
Correct.
grandfather. Yeah.
All right. All right.
Very interesting, and bitin na naman yung
All right.
time. Yeah.
Dapat mag-part 2 na naman tayo for estate planning. We haven't really touched that. 1 hour is certainly not enough. So
Yeah, Attorney DJ, thank you, and Attorney Dong. And
Anytime.
yes, before we go pala yung question pala, pagka joint account, is it legal for one of the spouses to withdraw money?
To the extent of what she owns, 50%, yes, theoretically.
Kasi mga banks, di ba, usually they say, kung buhay,
Yeah.
you certify na buhay pa yung co-depositor.
one last
Humahabol pa, kailangan naman.
May someone asked this, can husband and wife do a joint will?
Yeah, but
Can it be joint? In one will, the two of them are
are signing.
Yes, but the problem
One
there is
will.
When do you probate,
when will the
oh?
right
It's
acquire?
okay if they die both at the same time.
So you're saying for practical purposes hindi pwede, but legally
I don't
is it
see
valid?
any benefit by doing a joint will.
But you can bind your own share as a spouse.
Okay. So
There's so much in love in it.
yeah.
Or baka may intention mag-Romeo and Juliet, sabay sila mamatay. Okay.
Okay.
But
All right.
that's very interesting. Thank you so much, Attorney
Thank you
DJ
also.
and Attorney Dong. Thank you for helping
Thanks
us
for
answer
having us.
questions as well. We'll take another break. Legal Help Desk will be back, so stay tuned. Welcome back to Legal Help Desk on 9TV. And today we had a very interesting
Yeah, it's always good to have
topic
them, no? Si
on-
Attorney DJ and Attorney Dong.
Yes,
They're
and
very good,
again,
yeah.
one of the biggest misconceptions is that estate planning is only for the wealthy people. In fact, diba, to the extent na allowed by law, if you can really plan ahead, how can I efficiently pass on my properties to my children, to my grandkids? You should do it while you're still alive.
In
Kaya
fact,
nga-
the question nga, when do we do it? The answer is, there's an anecdote na when should I start estate planning? The answer is yesterday. Dapat you should have started yesterday because parang ano yan eh, parang you know, like credit card, when you owe some credit card debt, you don't want to incur any penalties, di ba, on the date that you had to pay and you didn't pay. Parang ganun ang estate planning, no? You have to start doing it now while you're young, and yun nga, even if you don't have, you said, not even for the rich people, but if you have assets, definitely you have to start planning. No?
Yes, and again, yung mga ibang types, different types of tools na allowed by law for estate planning is, one, you can either start donating properties to people that you want to benefit. So, kunwari, if there's a certain house and lot that you already want to give away to your parents, for instance, then you can execute a deed of donation and it will be subject to donors' taxes. And then, ano pa ba yung ibang
well,
types?
there's
Yung
also
corporation.
setting up a corporation. No? That's the usual thing that people do. No, there's tendency to set up companies. Normally, sometimes what they do, one property, one corporation. But we have some caveats there. No, obviously, if you're setting up a corporation, and it's great. What basically happens, you transfer your property to a corporation, and the corporation in turn will give you shares of stock. So now you're holding shares of stock na hindi na the property. The property is now owned by the corporation. In that regard, you can get a BIR ruling that's supposedly that's tax-free kasi wala namang ano yun, walang parang payment, no? It's just an exchange of assets. And then eventually, you can then transfer your shares of stock to your heirs. However, in transferring the shares of stock to your heirs, there's capital gains tax on the transfer of shares of stock. No? So meron ding capital gains doon. And you also have to consider that it's not purely, estate planning is not purely a tax avoidance thing, no? Or tax evasion. A lot of people are trying to avoid taxes. Estate planning also involves practicality. For example, do your children want to be in one corporation? No, if they're not, kung medyo nag-aaway sila, it's very hard to put one asset in a corporation kasi mahirap i-split yung property na yun, no?
Another device that they can consider would be trust. And this is creating basically a trust arrangement wherein you choose someone na tinatawag mong trustee so that if anything happens to you, ito yung hahawak ng either assets, ng money, and then you also designate a beneficiary, meaning this trustee will administer the property or the cash and then give it to the beneficiaries that you also designate.
Yeah.
And another thing you can consider also in terms of looking after yung kung sino yung mga beneficiaries nyo or yung mga potential heirs nyo would be insurance. So you can get insurance for them and you have to make sure that they are irrevocable para hindi subject to estate tax. Meaning, hindi mo na mababawi na sila yung beneficiary dun sa insurance proceeds.
Yeah, I think
And
important yung word na irrevocable, even in trust. No, if you put irrevocable, that means you have given that trust already. That will not form part of the estate. Some people do that in order to reduce the extent of their estate. when they make an irrevocable trust. All right. So
and another helpful tip for those out there na considering that they will plan based on a will, you can already probate, meaning pwede nyo nang i-prove yung validity ng will nyo even before you pass away. I know it sounds weird, but at least it ensures na kung ano yung will na ginawa ninyo, proven na siya so that if something happens to you, you know na masusunod yung will ninyo.
Yeah. Okay. So we know that 1 hour is never sufficient to cover estate planning, but we hope we were able to cover enough for you to have a working idea on how to plan your estate. All right. So moving on, we have received some questions and comments from our viewers on topics we have previously discussed. Melanie is asking, what will happen to the conjugal properties I acquired with my ex-husband after our annulment is granted? Do I still have a right over these? So so they got annulled, but for some reason they acquired properties together.
Baka naman they're good friends pa. But since you're already annulled, you don't have a marriage anymore, which means na hindi na kayo subject sa absolute community of property or conjugal partnership of gains, which are basically yung ways that property relations are regulated by the law between husband and wife. So in this case, para na lang kayong strangers to each other, legally under the law. So in terms of buying property, to the extent na may common kayong contribution, you can be co-owners of that property.
I guess to the extent, depending on the arrangement nyo, no? If the ex-husband gave, let's say, 60% of the price, and then you give 40%, usually
so
it's a 60-40 co-ownership. All right.
We have another question from Eugene. A friend borrowed a huge amount of money from me and hasn't paid me yet. There was no contract involved when this was done because she assured me that she would pay me back. Can I file a case against her and what?
Okay. Well, it's a collection. You can still file a collection case. Yeah.
Eugene, you can file a collection case. It's a civil case for specific performance for the payment of that loan. So kahit wala kayong contract in writing about the loan, you can still file a case against your friend. And then some qualifications though, hindi ka pwedeng sumingil ng interest dun sa, kung kahit may usapan kayo na yung utang niya, babayaran niya na interest, you cannot basically go after that interest rate if it's not in writing, because it's under the law. That's one of the requirements, that if a loan has to be paid with interest, the interest payment has to be in writing, yung agreement. But otherwise, pwede niya singilin.
Pwede, as long as you have, again, when you file a case, you have to have evidence. So ideally, there should have been people who, apart from you, who will testify that, may utang siya, or maybe some letters or emails that he sent that acknowledging that he or she owed you. No? So you have to have some kind of evidence as well. No? So,
and for others out there na nagpapautang, that's the benefit of asking for post-dated checks, because if it bounces and the person who issued it to you knew na wala naman silang sufficient balance, they can be prosecuted for estafa or BP22, bouncing checks law.
All right. Okay, now some comments, some positive comments. Stravinsky tweeted, "You have a nice show, good concept, unpretentious, and meaty." Wow.
Baka ikaw yung meaty.
I've never been called meaty in my life, but I'll take that. No, the content. I'm sure he was referring to the content. All right.
Okay, we have another comment. June posted on Facebook, "Your episode on ATM and credit card fraud was very timely and very informative. Thanks." Thank you so much also, June, for sharing that comment.
All right, very encouraging comments indeed, and keep them coming. Please visit our Facebook pages and our Twitter pages. So that's all the time that we have for tonight. We'd like to thank all our viewers who sent us their legal questions and comments on our social media page. I'm Atty. Nepomuceno.
And I'm Attorney Karen Jimeno. If you have any questions or comments on our topic for tonight, you may post these at our Facebook and Twitter pages. Join us again next Monday as we discuss your legal rights. Good night.
We're touching on this topic again. No? It's kind of related to what we discussed before in previous episodes where we touched on testate and intestate succession. Now naman, we're going to be talking about estate planning and probate proceedings.
Yeah. And Rod, you said a mouthful kanina, mga probate proceedings, testate, intestate succession, but I think for the benefit of our viewers, not to be too legalese, in short, this is all about mana, yung inheritance. If someone in the family passes away or a relative, this is all about how you can basically get your inheritance or how you give your inheritance.
A lot of people don't want to talk about it because it's normally about death or, you know, they think about death, di ba? Yun ang unang pumapasok. But I think perhaps we'll start off with that. No? Maybe at Atty. Dong, you'd like to enlighten our viewers why it's important to talk about estate planning and why it shouldn't be such a morbid topic.
Rod, just as a starting point, Atty. Dong was saying kasi kanina, yung topic nyo pang mayaman na. But I want to erase that misconception. This is not just for the wealthy because to the extent that you have something, the least that you want is to either depreciate what you're leaving to your mga descendants or yung mga may iwan mo. Make it smaller by paying a lot of estate taxes. Kasi kung meron namang way na legal to reduce that, why not, right? So maybe Atty. Dong and Atty. DJ, that's something that you can enlighten our viewers on.
Well, estate planning is first and foremost, it's a desire of the living to be able to transmit whatever he has to his heirs at the cheapest possible amount, you know? Less hassle. Now, what they say is basically
Of the deceased will be divided according to his or her wishes. A series of hearings must be held to establish the death of the testator, the genuineness of the will, and the competency of the testator at the time the will was made. This is done for the protection of the expressed wishes of the testator and not for the interest of the beneficiaries. Therefore, the questions are, what is estate planning? And can this be a better alternative for testate succession? Since estate planning involves taxes, what are these? How much are they? And who should pay them? And what happens in a probate proceeding?
Good evening. You're watching Legal Help Desk on 9TV. This show is about making the law work for you by giving legal advice on topics that matter to you. I'm Attorney Karen Jimeno.
And I'm Atty. Nepomuceno. In our previous episodes, we've discussed your legal rights on testate and intestate succession. Tonight, as part 3 of our discussion on succession, we'll discuss your legal rights on the following topics: estate planning and probate proceedings, what you need to know about estate planning and how this can be an alternative to testate succession or the making of a will. We'll also discuss what you need to know about probate proceedings and how.
Our guests for tonight are Attorney Alfred Lazaro, Managing Partner of the Lazaro Law Office, and Attorney DJ Jimenez, Law Practitioner and a Professor at the University of Santo Tomas. Good evening, gentlemen.
Good evening, Attorney DJ, Attorney Dong.
Hi, good evening.
Welcome again for both of you. Suki na kayo kasi.
For most Filipinos, death is a tough subject to discuss. Most do not plan ahead and therefore leave their loved ones to fight for what remains of their properties or estate, as is the legal term. Most Filipinos are not aware of the different ways they can impart their estate to their family and relatives. Aside from testate and intestate succession, another option they can consider is estate planning. Estate planning is a process of arranging for the distribution of the testator's estate according to his personal wishes and requirements. Similar to testate succession, only with estate planning, it eliminates uncertainties such as debts and reduces taxes and other expenses that come with death and distribution of assets. Estate planning involves tools such as wills, trusts, beneficiary designations, powers of appointment and attorney, gifts, as well as life insurance. Similar to testate succession, estate planning must undergo a probate proceeding in order for the heirs to get what is rightfully theirs. a probate proceeding is a process in which the estate
a consideration. But more than that, yung desire mo nga eh. Remember, unlike other jurisdictions, in the Philippines, although you can make your own will, but you are limited by the substantive limitations provided for by law. If you have compulsory heirs, you cannot just bequeath your property to
the church,
any person you wish.
Oh,
or to the
Attorney
church.
DJ, I'll stop you there. Let's translate it for the viewers na hindi lawyers. When you say limitations, because meron kang compulsory heirs, ito yung mga, for instance, if you have children, you're really required to give property to them. So
Yes.
kahit sa will mo, nakasulat dito that you're leaving your properties to your best friend and to your parents, kahit papano, yung will na yon, before it is satisfied, you have to give the
them
properties first
the
to
legitimate.
your children.
You have to give the legitimate, the compulsory heirs.
Unlike Lex Luthor, di ba? Yumaman siya dahil pinapirma niya yung...
yung ano
Are we talking about the character from Superman?
Yeah, because
This is what I get for being surrounded by men.
Just to
Did
make
you watch
it simple.
Superman Returns? No, but yeah, I think let's clarify that kasi a lot of people are asking me, Radhe, I have a will, or my lolo had a will, but left it all to kunyari girlfriend niya kasi maybe the lolo already died. Is that possible? No? And so to clarify, in the States or in other jurisdictions,
Yes, you can.
It's possible, right?
But not in the
But
Philippines.
not in the Philippines.
Well, if he is a Filipino citizen, no.
Yeah, so basically you have to set aside nga.
And if he has compulsory heirs, of course.
Yes.
And that is
Normally, a problem of the rich people is because if the estate is small, you don't even have to pay much taxes already because the bracket will be low.
In fact, what is the bracket? At what rate or the value of the
Well, I
asset
think
that
if
you
it's
don't have
up
to pay
to
any
1
estate
or
tax?
2 million, there's even zero tax.
So
2.2 million probably.
So 2.2 million ng estate mo, bali you don't have to pay any estate tax.
Not necessarily if the property left is a family home. So to the extent of the first 1 million, exempted yan. And then meron ka pang straight na 1 million plus the first 200 is zero rated. So in effect, if the value is 2.2 million, even if you proceed with the usual testate proceedings, whether extrajudicial or judicial, hindi ka rin magbabayad ng tax. But again, estate planning is very important because this will give you a better way nga as to how you would like your property disposed of in anticipation of death or incapacity.
So what are the different options? I mentioned earlier in the introduction nga, there are trusts, there are donations inter vivos while alive, no? We have life insurance. So perhaps we'll focus on that before we touch on probate proceedings. So let's begin. For example, I want to plan my estate. No? What's the very first thing that I need to do?
Well, you have to make an inventory of all your properties. You know? And then by coming up with an inventory, then you can devise what would be the best option for you. Indeed, the lesser payment of taxes is